Let's talk about your rights in California. All right, let's briefly talk about disability accommodations. So, in California, for employers with at least 5 employees, they're subject to the Fair Employment and Housing Act. And one thing that act requires, and the regulations implementing it, is if an employer is put on notice, just put on notice that an employee may need disability accommodations, then they are expected to engage with that employee in an interactive process. Now, I emphasize put on notice because that doesn't require a specific request from the employee, even though practically that's what we're talking about here. Now, the interactive process can look like a lot of different things. It could be providing medical information, it could be just describing the disability and discussing the accommodations that may allow that person to still perform their job. At a bare minimum, the employer needs to at least engage in a conversation with the employee about whether or not the employee may need a reasonable accommodation and what that might be. Now, there's a lot of nuance, and this is a very fact-based inquiry on whether or not the employer has satisfied that obligation. But if the employer does not at least engage in some sort of conversation or interactive process with that employee, chances are they have violated the law. Give it some thought. And for more about your rights in California, like and subscribe.